Protection Act, I believe it is. Amendments. We'll go ahead and begin.
With
Mr. President.
roll call.
Yep.
Okay. Representative Alman. Representative Angelos. Representative Haroldson.
Here.
Representative Pendergraft.
Here.
Representative Sherwood. Here. Representative Smith.
Here.
Chairman Bear.
Here.
Mr. Chairman, you have a quorum.
Thank you. Mr. President, welcome.
Thank you, sir.
You can please proceed as soon as you're ready.
Well, I have to apologize for the PTSD. Last time I was in this room, had a bill get absolutely gutted and substituted on me. So if I'm twitching a little bit, that's why. All jokes aside, though, I bring you the Second Amendment Protection Act, Amendments 3, Senate File 101 engrossed. Obviously, you all have seen this bill before. We saw it last year, passed out of your body on, what was it, 53-7 or something like that. Our body passed it on almost unanimously last year, got vetoed. We didn't stick around to override the veto. Your speaker and myself put out a press release saying this would be a top priority for us coming back in the 2026 budget session. We kept our word. We made it a top priority. That hence the mirror bills in the short budget session. I bring you the Senate file version of this bill. As you'll see, the only difference, I think, than the House bill on the engrossed version, if you look at what we did with subsection D on page 5 and over to page 6, trying to finesse the language with LSO to make it more workable on the penalty section dealing with the agencies. As you know, with this bill, you have the subsection C, which deals with basically an offense against a law-abiding citizen. And then subsection D deals with an agency who knowingly violates the act by one of their employees, how to deal with that. And so what you see is we've added A and B in Romanet 2, which looks a little different than the House version, trying to get at the same thing, just a different way of doing it. And then you'll see a new E, which tried to move the paragraph that says an interested party may bring a civil action to enforce the provisions of this section. You've all seen that, that problem child. I'm assuming you probably have an idea where you want to put that thing. That thing is supposed to be a qualifier for D, not C. So we don't necessarily want that interested party language to qualify for C, because C is a crime against the law-abiding citizen. That E portion should belong under D somehow. So if you guys can figure out a way to wordsmith that in, much appreciate it. If not, I think it's okay where it's at, but I'll stand for questions on that where I deferred any experts on that, on the language there. But everything else you see before you, Mr. Chairman, is the same. And let's just get this bill done and get through the process. I'll stand for any questions unless Representative Worf wants to elaborate. I yield to Representative Worf.
Representative Worf, welcome.
Thank you, Mr. Chairman. Happy to be before your committee again, and I would just echo what the good president of the Senate said. I mean, this is a bill I think we're all pretty familiar with, and I'm just here to answer any questions if I can add to it.
Okay. Mr. Vice President, did you want to opine? Okay. Any questions for the president or the representative?
Thank you.
Sherwood.
Thank you, Mr. Chairman. Just so everybody gets the same opportunity to answer what I asked before is, so it's clear to the public, what Wyoming problem is this bill trying to solve?
Mr. President.
Mr. Chairman, through you, this is to protect Wyoming citizens from having our law enforcement be used or co-opted or whatever commandeered by the federal government to enforce federal gun control laws. It's of high importance to our gun owners, high importance to our citizens, Mr. Chairman.
Follow up, Representative Sherwood.
Thank you, Mr. Chairman. Are these violations happening today? Is the problem we're trying to solve something that's happening in the state now?
Mr. President.
Mr. Chairman, it could happen any day. Any president could issue an executive order by fiat to to confiscate our guns, for example. That could happen tomorrow. We don't know. But these amendments are necessary to protect our gun owners and our law-abiding citizens in this state.
Okay, further questions?
All right, one more.
Sure.
So if you could recap, what has changed in the bill to address the reasons our chief executive vetoed it?
Mr. President.
Mr. Chairman, I don't have the veto letter in front of me to answer that.
Okay. All right, any further questions? Mr. President, we did address the similar bill, Representative Worf's bill in this committee that passed through and is over on your side now and moving forward. We ran into concerns with the gentlemen and ladies that are behind you as far as communication. And I'm just curious, you know, since the actions of last year, have you had any communications with the sheriffs, the WASCOP? Can you just share with the committee how those conversations have gone? Has there been efforts to try to appease them at all?
Sure, Mr. Chairman. Yeah, I did receive an email back when this bill was up in the Senate side. I think the day or two before the committee reached out to the person in charge of that organization, offered to work on specific language to address specific problems with the bill during committee. A lot of generalizations were made about what the bill did or didn't do, but I didn't hear anything specific with regard to the actual language of the bill that would prevent them from, for instance, cooperating with ICE or DEA on drug enforcement issues. Since this bill solely deals with, if only applies if the underlying issue is to violate Second Amendment rights. If it's a gun issue, like a gun confiscation order or something to that effect, does not preclude law enforcement from, no more than ever, does this bill not preclude our good law enforcement from joining task forces, for instance, with ICE or anything like that.
Okay, so what I'm hearing is that no communications from last year when you and the speaker made a comment that you would be bringing this back this year. There was no communication during the summer where they reached out to you to say, we have issues with this as well.
No, but in their defense, Mr. Chairman, I didn't know I was going to sponsor this bill till very late in the process, like a couple days before session. If not, that's why my name's on it and I wasn't able to get co-sponsors because I had to file it right away. So in their defense, they probably didn't know I was going to be the sponsor of this bill. I assumed that I was not going to be, but in the Senate, senators can only bring 3 bills during a budget session and most of my senators were full. And so I took it upon myself to do it because I did make that pledge to the voters last session to, with the speaker, to make sure that this got done.
And correct me if I'm wrong, but Mr. President, that your comments and the speaker's comments were in the newspaper. They were very public.
Yeah, I would agree with that.
Okay. All right. Thank you.
Thank you, Mr. Chairman.
Any other questions for the president? Okay. Representative Worf, I would like to ask you that same question since you did sponsor a bill and have your name on it pretty early on. So please share with the committee and the public.
Thank you, Mr. Chair. You know, we did have some conversations. I know, as I recall, last year we had a paragraph that we brought in to the SEPA bill that came from the WASCOP. And this year we added one as well. We accepted the one that's actually on the gross copy Senate file 101 on page 9, lines 5 through 8. And that is an amendment that came from them. So we did have some dialogue, some interactions. I thought I shared well, I'm not going to say that, but I do know we have always tried to work with them. I know that sometimes I think they express the feeling that they're not listened to. I just think we haven't agreed with some of the positions they've tried, some of the amendments they've tried to put on the bill. I think it's obvious that we kind of got 2 different camps here. So with that, there was an effort on our part, but a lot of it was the same stuff that they brought forward last year that we didn't accept, and we didn't accept it again this year either, Mr. Chairman.
Any further questions for the representative? All right, any questions for the vice president? Okay, gentlemen, thank you. Okay, we have the governor's office. We'll have, no, okay. Any representatives? Any elected officials? We've got some sheriffs in here. Let's have any sheriffs come forward. We have? All right. Any departments? Anyone from the public? I've got some online testimony. Please come forward, sir. Ms. Childress, we'll go through this first round here, and then we're going to go to online and get these. Is there more than these two that I have here?
There is an additional gentleman, Sheriff Jeff Hodge, as
Okay.
well as the two that you have
All right,
listed.
if you'd let them know, as soon as we're done with these people, we'll get to them. And I'm going to make a statement here right now for everybody in the room and online. We dealt with this bill last year, and there was some criticism that not enough people got the opportunity to be heard. So we're going to take our time and hear everybody out. And so if this goes beyond today, we have reserved our tomorrow morning meeting to complete the testimony, but we will act on this bill either today or tomorrow morning. So we'd like to give everybody an opportunity to be heard. So we'll start today, and we'll start at this end here with you, sir. Please introduce yourself to the committee and to the public, and let us know your thoughts on Senate File 101.
Perfect. Mr. Chairman, my name is David James. I'm a captain with the Cheyenne Police Department. I am a second generation Wyoming law enforcement officer. And 22 years ago, I took an oath to defend the Constitution and laws of the United States and the Constitution and laws of the state of Wyoming. And I spoke with you all last year about this as well. And you know, we spent most of the week this week with the majority, if not all, the sheriffs from the state of Wyoming, and most of the chiefs and several other commanding officers and line officers. And the overwhelming consensus that came out of that is concern that even though that may not be the intent of this bill, this doesn't feel or seem like a pro-gun bill, but an anti-law enforcement bill. It concerns all of us when we try to criminalize law enforcement for doing their job, especially when we talk about removing words like unconstitutional. Unconstitutional has been the standard that law enforcement has worked with my entire career. And some of the testimony in a different meeting said that they wanted to remove the word unconstitutional because then it would be up to the courts to decide if the actions were unconstitutional or not. Well, to me, that sounds like we're trying to take due process away from our officers and from our departments of doing their job. That's why the courts are there, to determine if it's unconstitutional or not. And so that's one of the big concerning parts to me on this one. Like I said, I do really appreciate the purpose of this and why we're doing it. You know, like I said, I swore to defend our Constitution and laws, and Second Amendment is something I hold very, very dear. But I'm also very concerned. You know, I just heard that, you know, a lot of the examples brought up were not specific. Well, it's hard to bring up specific examples when we have very unclear, not specific language in this bill. And some of the things that really concern me that kept being said in a different committee was that, you know, officers can still enforce the laws of Wyoming while working with the federal government if the initial contact involves something other than guns. Well, it doesn't say initial contact in the bill. Okay, that is one of my biggest concerns. It says in the bill that enforcing any act, law, treaty, executive order, rule, regulation of the United States government solely regarding firearms. What often happens, especially if you talk to our U.S. attorney, 45 to 50 cases a year go through our U.S. attorney's office involving prohibited offenders. And we like to go through the U.S. attorney's office because they have amazing sentencing guidelines when it takes to getting these violent people off our streets. Well, the federal laws on prohibited offenders are significantly dissimilar to the Wyoming laws, especially if you talk about domestic violence convictions or you talk about nonviolent felonies. In the state of Wyoming, a nonviolent felon in possession of a firearm is a misdemeanor. In the federal courts, it's a felony. So it's really hard to say that those are not similar laws as they're going. And then and that when you look at whether it's solely that law, it gets broken down. You know, we had a U.S. Marshal, our task force officer, recently arrested a sex offender out of northern Wyoming that was wanted for raping a 15-year-old. We ended up finding that person. There were also gun charges. Any of these cases that go federally, there's a really good chance that all of these other things will end up getting dismissed and they'll get convicted on the gun charge. Now that is solely a gun charge. It's very unspecific in this bill on now whether that officer is liable for criminal prosecution and the department liable for $50,000 for prosecuting a dangerous individual. Yes, it may have initiated as something else, but now we are looking at it solely a gun charge. This happens all the time. Narcotic investigations. All the time we're working narcotic investigations. We catch an individual with narcotics and guns and they're a prohibited offender. And then they end up getting charged with only the gun crime. One, because it's a little easier to charge them on the gun crime as opposed to the narcotics crime. And the feds kind of dance around the narcotic stuff sometimes. And so we often see that. So for us as a department, you know, when you're a police administrator, you're constantly running risk management, right? And so when we look at, are we going to fill, we have 5 officers right now as part of a DEA task force. We have 1 officer who's jobbing it, doing an amazing job as a U.S. Marshal task force, catching fugitives. And so now we have to weigh the risk and reward of putting these people in these positions. Is it worth the risk to us? Is it worth the risk to them to even have them on these task force? Because one, it was brought up yesterday in the committee that, well, in Missouri, this was brought up by an out-of-state lobbyist that in Missouri, their law, it went on for a couple years and there was only a couple lawsuits, but they were frivolous and just went away. Well, we still have to fight frivolous lawsuits to get them to go away. It still costs the taxpayers lots of dollars to fight frivolous lawsuits to go away. And so we have these lawsuits that this is going to invite that may be frivolous, but without it wouldn't even be filed. And so it is one of those things where Alan's going to talk about some amendments that he proposed. These amendments definitely offer a lot more confidence to our department and to our officers and give us a lot more confidence when it comes to continuing on with these task forces and doing the amazing work that these officers are doing. We're taking some really dangerous people off the street that in the end are charged with solely gun crimes, but it didn't start out that way. But this law doesn't say that that's what it is. It says solely in there. It doesn't say how it starts as we go through. And so, you know, there's a lot of concerns. I do appreciate WASCOP and I appreciate the amendments that they worked to put together so that we can hopefully make this a more workable bill for what we do so that we can continue to take bad criminals off the street and keep everyone safe. One more thing that was brought up that killed me yesterday was that once a firearm is seized by law enforcement, it goes into a black hole and never comes back. Well, one, we can't seize a firearm unless we have the constitutional ability to seize a firearm, which is very narrowly defined. But every once in a while, like I can think of sometimes we get suicide attempts or things like that where there's a firearm in the vehicle, or a crash where there's a firearm in the vehicle. Now we're towing the vehicle. Well, we want to keep that firearm safe. We appreciate the Second Amendment so much. We want to keep that firearm safe, get it back to the family. So we immediately take it back, and within a day or two, they get a letter from us saying, please take this firearm. We don't want it. And so to allege the law enforcement takes firearms and puts them in a black hole to then go disappear is just, it's not an accurate reflection, especially as Wyoming law enforcement. And if you've ever seen an evidence room, we work really, really hard to get rid of property. And if property is there for safekeeping and it's not evidence, the last thing we want is it clogging up space in our evidence room, and we want to get rid of it. And so again, I really appreciate the purpose behind this. The political statement that we want to make here, all of us want to say that we're pro Second Amendment. Absolutely. I would happily go to the range with anybody and go shooting. We love our Second Amendment here in Wyoming and we live by it. I hope everyone is armed in this room. But I also don't want to criminalize law enforcement for doing their job. And so I want to work on that. And I thank Alan Thompson, and he's got some great ideas as well. So I stand for any questions.
Okay, questions for the officer? Representative Harrells.
Thank you, Mr. Chairman, and thank you guys for being here, all of you. This is a conversation, and I know when we had this conversation on House Bill 130, one of the conversations and the questions I asked, and I guess a frustration that I expressed is, I mean, it was pretty obvious when that news article came out last year, the intention of the legislature is to put SAP on the books. That's the reality. Now, what we have is we have the conversation starting once we're already in session, once the process is in play, and that falls on both sides. I'm not letting anyone off the hook on that. I think that's all of our faults in a way. But there is a frustration as we sit here and say, how do we protect the citizen? Which you guys all want to do. I don't doubt that for a second. How do we protect law enforcement? Agreed. But there's also the point where in that process, we don't tip that so far that we lose sight of one side or the other, right? And that's the battle that we're trying to balance here as we look at this. And so with this conversation, as far as Second Amendment preservation, you guys have to realize I have constituents, a pile of constituents who are like, don't listen to them. We don't trust them. And I hate that. I want that to sink in for a second. How did we get here, you guys? Right? And so there's a point where we look at what has potentially come out of our federal government. Right now, we're in a good place. Right now, I don't think any of us are concerned about that. But we've just not that many years ago, we were seeing stuff happen coming out of DC that was scary, really scary. Stuff that would potentially wake us up to a point where we could lose rights. And they would sit there and go, oh, well, it's in the name of safety, or it's in the name of they could put a mask on or whatever they want. And so the question that I would ask you is, how do we balance that? And I know you guys have an amendment that you brought, and I know that we've had that conversation Senate side. But then I have on the flip side where people are very much upset about that, saying this is going way too far the other direction. So can you talk a little bit about that, of what that balance is of wearing two hats? Because you wear the hat of a citizen of the state and you also wear a hat of a law officer of the state. And can we talk about that balance? Can you kind of just opine on that, please?
Officer Jennings?
Yeah, absolutely, Mr. Chairman. Well, one, we wear more than two hats. Okay, I mean, as a public administrator, I think a big important job as public administrators is to also represent the people that we serve there as well. Okay, much as you represent the people that elect you, we have to represent all the people that we serve. And as we look into this one, we already have a SAPA bill that covers most of this. This just adds a few things, like I say, takes the word unconstitutional out of it, that really makes it difficult for law enforcement as it goes. Two, most of what I've heard is the exact same things that were said last year, right? And so these are things that we're wanting to be heard as we go. But yet I also see a lot of things online and a lot of misinformation sent out by out-of-state lobbyists, out-of-state people who are trying to tell Wyomingites what's going on, who are trying to tell Wyomingites what they should believe or how they should believe it, or that they should mistrust their law enforcement. And to me, that's extremely concerning. But it's really difficult in law enforcement because we have this weird job where, we get our legitimacy from the trust of the public we serve. And so it's also really difficult for us to do many things like this because we need to be seen as an unbiased agency as it goes. So it makes it, we kind of get put in a rough spot to where it's hard to actually do much. We can't lobby, right? The Cheyenne Police Department cannot lobby for stuff in the interim. I always welcome when people call me or people email me. In fact, I had an individual today ask about some other things we do, and he's in politics. I said, come down to the police department, I'll show you, right? We can do those things very easily. It's a little more difficult for us to take political action. And that's, why we have things like WASCOP that help us on those things. But I mean, again, these are all the same things that were being said last year. The amendment was brought up by those, and it's a fantastic amendment. But again, you made a great point. We're citizens of Cheyenne as well. The citizens are citizens of the state of Wyoming as well. All 23 sheriffs elected in the state of Wyoming were against the SAPA bill as it's written right now. All 23. And many of the chiefs and those that got around to signing it were as well. And so they're representing their people as well. And so there may be some people voicing their distrust of law enforcement. I would also contend that that's a very, very small vocal minority. voicing that concern, because the people that I deal with, the people that I talk to routinely tell me that they're happy we're out there doing the job and that we're happy that we're out there protecting their Second Amendments. Because I tell you, if and there's case laws making it clear as can be that the feds cannot make us do any of this. The feds cannot come in and make us take guns. And if the feds showed up and started taking guns, I'd be the first one in line to start throwing them in jail. Okay, so we have that here in Wyoming, and people do trust us because we're willing to do that.
Vice Chairman Pendergraft.
Thank you, Mr. Chairman, and thank you for being here and talking again. There was a question asked earlier about, does this solve a problem in Wyoming? So I'm going to ask the three of you, can any of you cite an instance in Wyoming that this bill might have addressed?
I'm going to limit that to Mr. Jennings for right now. We'll get to the other two of you when it's your opportunity. Please keep that in mind. Representative Pendergraft will follow up with the other two if need be.
Yeah. Mr. Chairman, thank you so much for your question on this. And in my 22 years of law enforcement, I cannot think of a single instance of Wyoming law enforcement enforcing or helping enforce unconstitutional federal laws to take people's guns.
Okay. Any other questions? All right, Officer Jennings, I do have a question. So there are a couple here. I heard you really clearly when you said there's 45 to 50 cases a year where starts out as we're going after a drug case, but it ends up we use federal prosecutor to go after gun crimes, and it puts bad people away for a lengthier time, which is what we really want, keep these people off the streets. Heard that real loud and clear. So my first question is, based on your comments, what do you see as the significant differences in drug sentences between the state and federal charges? And then I'll have some follow-up from there.
Yeah, Mr. Chairman, I actually see when our DEA people do crimes through federal, they get more a more strict sentence for drugs as well with the federal government. But what happens with a lot of these is drug cases are typically harder to prove, right? If I'm a narcotics agent and I stop a car that, you know, an hour ago I knew the person who told me had drugs in it, I stop them for a legitimate stop. The dog indicates on the car, you know, they've just left a house where they're manufacturing drugs, but now there's no drugs left in the car, right? That happens, but they have a firearm and they're felon in the car with a firearm. Well, they're not going to charge them with a narcotics crime, even though it started out as a narcotics investigation. And so, yes, typically sentencing guidelines there tend to be better than the state as well, plus the workload. I mean, we constantly work with our DA's office and says, you know, our city prosecutor's office is overworked. DA, can you take more city cases? DA is like, absolutely not. Our DA's office is overworked. They say, U.S. Attorney's Office, can we start referring more of these to the U.S. Attorney's Office? And so the last thing you want is right now it is spread out to where they're handling the absolute most workload that they can handle. But yes, overall sentencing is much more favorable for the citizens of Wyoming with the federal sentencing guidelines.
Okay. That leads into my next question, and you brought up risk management, which I think is a legitimate concern. But as these cases would be shuffled off to the federal prosecutor, I'm assuming that there's a relationship, because the federal prosecutor is going to definitely want to work with you as well, because that gets bad guys off the street. He or she's trying to do that as well. So when the issue started out as a drug task force, and then the prosecutor has a lot of leeway in how they're going to prosecute the case, and they decide, well, we're going to go after a gun charge solely.
Mm-hmm.
And this law, should it pass, is in place. And then they're going to understand they're putting your agency at risk. They're increasing the risk. So can't that prosecutor make determinations based on that risk assessment? If the guy's really bad, go ahead and take the risk. If it's not worth it, stick to the drug charge. Is that a possibility?
Yeah. Mr. Chairman, that's a fantastic question, because that was the exact concern voiced by the U.S. Attorney on Tuesday when he spoke to us as a group. He is extremely concerned about this legislation because of that, because it hamstrings his ability to do his job. And in fact, Everyone doesn't know he was part of this legislative body just a year ago. And as he starts looking at it with a more objective and wide lens at the purpose of how the justice system works in Wyoming, he's very concerned about it because yes, it is a possibility, but oftentimes you get to a point where the only option you have is to charge that felon in possession of a firearm. And he's a prohibited offender because of a nonviolent felony. Therefore, it's a misdemeanor in Wyoming, but a felony for the feds. So now all of a sudden we significantly risk a chance of falling liable under this legislation. So it is absolutely something that we have a great relationship with all of our prosecutors. We are so lucky in Cheyenne and Laramie County because we work great with our prosecutors. But it really does put us all in a really tough spot. And so that risk management, as we talk to our attorneys and we talk to our insurance provider, it may be just one of those things where we may have to step away and no longer work with the federal government on any cases. And then we have these major cases going away and people not getting arrested and continuing to be on the streets in our community.
So by making that risk assessment from your standpoint and not engaging in task force work with the federal government, you're telling me that you really don't trust that federal prosecutor to make that choice for you.
Mr. Chairman, we absolutely trust federal prosecutors. There's sometimes they don't have the opportunity and the choices.
But prosecutors make choices like that all the time, whether they're going to prosecute or not. Couldn't they take this into account as well?
Mr. Chairman, I would hope they do take it into account, but that's part of the risk assessment that we're going to have to make.
Thank you.
But again, sorry, Mr. Chairman, some of these amendments, especially the adding of the word unconstitutional, significantly reduces the risk. Almost gets rid of the risk completely because that is already the standing procedure, already the standard that we work by.
Okay. Mr. Jennings, I've heard concerns about this bill taking away qualified immunity. There's always been a lot of hullabaloo about, removing qualified immunity from our officers. I don't think this bill or this body has any intent of doing that. But I just want to ask you, you didn't bring it up. Is there concerns when this bill deals only with sovereign immunity that it would lead to a qualified immunity issue?
Yeah, Mr. Chairman. So I have concerns more on the optics, right? Because sovereign immunity is the agency, is the entity itself. But to throw it into a bill, it's basically assuming that it's clearly established law right off the bat, right? And there's always things that are ambiguous. There's always things that are misunderstood. And so your qualified immunity for your officers says that if they violate any clearly established law, they don't have immunity. And that's one of the very first things we do in these lawsuits is the judge decides whether the officer violated or could have in light best favorable to the plaintiff violated clearly established law. So I'm not as concerned with that other than the optics. That it looks like we're looking at going, okay, you have to play by rules even if you don't know what the rules are. But I do understand the purpose of that is going at the agency and the department rather than the individual officer. And so I think most people understand that, or people who are in the realm where we deal with lawsuits all the time understand that. But it almost seems, well, why does it have to be in there? Because the sovereign immunity is going to be evaluated anyway for the agency. But I am happy that it doesn't mention qualified immunity, but it also doesn't mention civil liability towards officers. So it shouldn't mention qualified immunity anyway. It mentions only criminal liability towards officers.
Okay. Right. Any further questions? Representative Harrelson.
Thank you, Mr. Chairman. Sorry, you're getting hammered, buddy. But so one of the things you guys keep talking about, so in the state of Wyoming, if a felon has possession of a firearm under Wyoming law, you said it's a misdemeanor. If it's a nonviolent felon, it's a misdemeanor. Violent felon, it's a felony. Federal law, it's a felony on either count. So at that point, it still falls into the category of the law. And so, there's that dual sovereignty doctrine concept going on here that I guess I'm struggling with seeing how that I think we're almost talking about a non-applicable case here. because it is still illegal no matter how you slice it. It be a misdemeanor or a felony. It doesn't matter if it's that dual sovereignty, that federal prosecutor can say, hey, I'm prosecuting on a federal level because it's illegal on a federal level. Your officer detained an individual on a state level, but it doesn't matter if it's a federal or a state. Does that make sense? I mean, as I look at that and as I've had, because this is it, there's a lot, I mean, there's been hundreds of attorneys that have looked at this on every side of the equation. And I almost think that firearm in possession of a felon probably is a bad case to be using, because I believe in either way, this one's covered. Now, I will say, if it's a situation where the federal government says, I think that pink guns are wrong. And you go, okay, well, we're going to collect those. Obviously, now we're in an area where Wyoming has no conversation about that. And I used a very abstract extreme to just bring the clarity. That's completely in a different lane. And you don't have to answer this. Maybe this keeps going down the line, but I think this is, I believe here, we can, by this very clearly, Wyoming laws can be enforced by Wyoming officers. And if a felon is found with a firearm, that's a Wyoming law.
Mr. Chairman.
Captain Jim?
Perfect. All right. So I would love to answer that. So I think, one, we're talking risk management and how much we expose ourselves. And it says in here that against such, and we're on line 1 of page 8, violations against another person when such prosecution includes weapons violations substantially similar to the laws of the state and to the laws of this state, if such weapons violations are ancillary to such prosecutions. And so I think you may think that, a lot of people may think that, but I guarantee you the plaintiffs and the Trial Lawyers Association will be jumping all over themselves to say that federal prohibited offender laws when it comes to nonviolent convicted offenders are substantially dissimilar, because it's a felony as opposed to a misdemeanor in Wyoming. And I spoke about domestic violence. I'm really surprised that Zonta hasn't come in here, or other victims of domestic violence organizations haven't spoke out about this, because it's not against the law in Wyoming to be convicted of a domestic violence offense, but it is against federal law. So that one's not even covered. So that one's completely different. And so if all of a sudden those prosecutors decide to just bring that prohibited persons case up on because they're prohibited because of domestic violence, which I think anyone who's ever worked in law enforcement can tell you that domestic violence, it escalates and gets extremely, extremely scary. And in fact, one of the legislators yesterday testified that it wasn't brought up in our legislature because the federal government has it covered. And so no one ever bothered up even bringing it up, because that's an area that's covered. So now we open ourselves up to saying that, okay, well, domestic violence offenders who may be very dangerous, state of Wyoming can do nothing about it or do nothing to work with the federal government about it, because we open ourselves up to that civil and criminal liability. So I think the word substantially similar, to answer your question, it's not clear, and it doesn't make it very clear. And I think plaintiffs' attorneys will be jumping all over themselves to see us in court on those ones.
Representative Pendergraft.
Thank you, Mr. Chairman. Question real similar to what we were just dealing with. My understanding is if let's say we're out on a drug and we realize that there happens to be a violation of federal gun laws, felony and possession, and we know that it has a more stringent, we can put them away longer. So we're going to opt for that. So my question is this: is it not illegal, according to Wyoming statute, for a felon to possess a firearm? And would it be better if Wyoming increased the penalty for the same so that we could rely on our own laws and take care of it in-house and not have to worry about federal law?
Captain Jim?
Mr. Chairman, I would love if Wyoming changed their laws to make all felons in possession a felony, rather than just violent felons. This is something that our officers struggle with every time we contact a felon in possession of a firearm, is what do we do with this? I don't know how many times You know, I've had to go back to our officers and go, no, you can't charge him with the felony version of felon because you haven't looked at his criminal history yet. It involves a lot of extra investigation on the street trying to make a decision on what to do with a felon. So I would love if Wyoming had if it was all felony and if it included the domestic violence convictions. I think those things would really help protect Wyomingites. But right now, if this bill passes this year, we have until next session to make sure that we protect those individuals in the state of Wyoming that right now we can only do with the federal government. And again, I go back to, I do appreciate the federal government's sentencing guidelines as they go. And I appreciate our relationship with our federal partners and our ability to use their resources when looking for these very, very violent offenders.
Okay, thank you, Captain Jennings. Mr. Thompson, please introduce yourself to the committee and the public and give us your thoughts.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director at WASCOP. I want to briefly start by saying we did submit amendments today. You've seen them before, but they look different because the lines and the pages are different. And some of them that you might have seen last time are no longer on there because this is just the amendments that were adopted by a different committee on a different bill of the same content, and trying to make them exactly the same as they proceed was the attempt in the amendments today. But I would like to just skip forward. We've talked about the amendments. I'd be happy to go line by line if you guys have specific questions about those. But the questions that were asked earlier, we've been talking about a lot of hypothetical situations. What if this happened and what if this happened and we wouldn't be able to charge this or we wouldn't be able to charge that. I would like to draw your attention to press releases from the U.S. Attorney's website for the state of Wyoming just in the last couple of years. We have a case where we announced that a man from Cody, whose girlfriend disappeared while the couple and their 2 children were returning from Alabama in October of 2023, was sentenced to 87 months in federal prison for being a felon in possession of ammunition. A felon in possession of ammunition. That was a case that was initiated on the local level and working with federal partners and presented to the U.S. Attorney's Office. That person is still missing. And there is somebody that is in jail right now for 87 months simply for possessing ammunition, which is not similar to any law in Wyoming. There is no law, to my knowledge, about a felon possessing ammunition. And that would meet the strict definition of firearms, accessories, and ammunition are specifically mentioned in this bill before us today. Another example, a person up in Worland was sentenced to 18 months in prison for possessing machine guns in violation of federal law. I am not aware of any state statute that prohibits the possession of things like Glock switches. Now, I'll be perfectly clear, in this case, this person was arrested for driving under the influence. So that case did not start as solely a firearms case. But nothing in this bill leads me to believe that when you're prosecuting solely about a firearms case, solely about federal law, rule, act, treaty, all those words, I would be confident in saying our Wyoming local law enforcement would not proceed to recommend or provide material support to the U.S. Attorney's Office to further that investigation at all, and arguably could be in violation of this law by simply calling up the U.S. Attorney's Office and advising them that Mr. So-and-so in so-and-so Wyoming is in possession of a Glock switch. We have another instance where a person in the middle part of the state was sentenced to 53 months in prison for being a felon in possession of a firearm. Okay, we've talked about that already, but let's start at the beginning of the investigation. Officers were sent out for a report of a discharged firearm. Investigation at the scene would indicate that rounds were fired up in the air. Okay. Based on this press release, it appears this occurred inside the city limits of Riverton, but it's not clear. But let's say they are. There's probably, most municipalities in Wyoming have an ordinance prohibiting the use of firearms within a city limit. That's not a state law. There's no reference in this bill before us to the similarity between state law or municipal ordinance. That is not in there. So I would guess that all three of these cases are actual examples of times that I've talked to administrators across the state. If they were faced with these specific circumstances, they would not further the criminal investigation or prosecution of this by partnering with the U.S. Attorney's Office. Thank you, Mr. Chairman. I have other points if you want.
Yeah, Mr. Thompson, I'd like to ask you about that first case, with missing persons. I mean, you're alluding to that person being the guilty party in the missing person case, but I'm not hearing you say that they are guilty of that. So we put them away for 87 months, but maybe that's not even the person that committed that crime. Is that a safe assumption?
I could read the entire press release for you, sir.
No, I
Okay.
don't think that'll be necessary, but just trying to look at this through the lens of the innocent until proven guilty situation. So, but please proceed.
And Mr. Chairman, law enforcement, when they continue to investigate a case, probably very thankful in this case that that person is not able to alter evidence or otherwise continue to diminish the agency's opportunity to find this missing person.
Sure.
Mr. Chairman, we were questions earlier about the intent of this bill, and I think every law enforcement officer in the state of Wyoming wants to be in a position to support the intent of this bill. And the intent of this bill, as I understand it, is to prohibit the federal government to come into Wyoming and tell local law enforcement what to do. We're talking about a hypothetical there in the future that may or may not happen. And I would like to draw your attention to a decision brought on by local law enforcement in the sweeping gun laws from the early 1990s that initially federal gun law required local law enforcement to complete background investigations pursuant to the purchase of a firearm. Sheriffs in the United States filed suit and fought it on the local, state, appellate, and up to the Supreme Court. And in the decision from 1997, Prince v. U.S., the ruling is that the federal government cannot tell local law enforcement what to do when it comes to federal law. In any of the cases that we're looking at here with the U.S. Attorney's Office, any of the examples that we've contemplated or hypotheticals that we've given, I cannot think of one instance where the U.S. Attorney's Office has directed local law enforcement to investigate a case and provide evidence to prosecute. Each one of these instances that we do partner with our federal agencies is out of convenience and expertise and the ability to use equipment and funding and the criminal justice system on the national level to leave it in the hands of local law enforcement. Oftentimes elected officials are working directly for other elected officials that are seeking that help and expertise from our federal partners to prosecute some of the worst actors that we face in the state of Wyoming in order to secure longer jail sentences related to that. And I would just say that we already cannot enforce directions by the federal government. If you look at Prince v. U.S. and any of these cases that we're mentioning are driven by the decisions of local law enforcement, oftentimes in consultation with their county attorney. And those are also elected officials that are responsive to the people. And I would say that I'm hearing from our leadership that they have constituents also that want us to have the tools to deal with violent criminals and hold them accountable when not giving them a $50,000 payday on a technicality. And Mr. Chairman, I think those points were the ones that I just wanted to make, and I'd be happy to answer any specific questions about the amendment discussion if you would like to.
Representative Pendergrass.
Thank you, Mr. Chairman. So I would pose the same question to you, sir, as I posed to the good captain. Can you think of any instance here in Wyoming that have been affected by this law, if this became law?
Mr. Thompson.
Mr. Chairman, I do strongly believe, based on what we know about the case in Cody where a person was charged with simply possessing ammunition, that this would absolutely have affected that and resulted in not reaching out to the federal government to provide any material aid or support in that investigation.
Follow up, go ahead.
Thank you, Mr. Chairman. So I can think of one that happened in my county, which is also your county. November 21, 2023. We had a couple of sheriff's deputies, we had VCI special agents, we had a town marshal, and ATF agents. Raided the house. The man within had been, as far as Wyoming is concerned, expunged. He had every right to have those firearms. Can you explain what happened there? See, this is the type of situation that concerns me, is I hear reassurance after reassurance from law enforcement that we would never do that. And yet, on November 21, 2023, it did happen. Any response?
Mr. Chairman, I don't know the particulars of that case specifically, but I do know in talking to our law enforcement leadership that if a federal law enforcement agency were to come to town tomorrow, our leaders are confident that they would receive a phone call and ask for support in whatever operation they're doing. And they also feel that if this bill becomes law as written, they will never receive a phone call from the federal government again when they come to town, and do not have the authority to prevent them from enforcing federal law within the county.
Please.
Thank you, Mr. Chairman. Maybe I'm just naive, but it's my understanding that in each county, the sheriff is the supreme law, and they have the right to tell the feds to get out. Is that not true?
Mr. Thompson.
Mr. Chairman, I would love to be pointed to a statute that gives them that authority. And I think more importantly is it's not the fact that if they have the ability to try and combat that, I think they will. Problem is they're not going to know they're there until after they've been there or maybe even gone.
Okay. Hello. Other questions for Mr. Thompson? Okay. Mr. Thompson, there's been some conversation about the letter with 23 sheriffs on board. Were you integral in getting that letter drafted and all the signatures on that?
Mr. Chairman, I compiled that and confirmed signatories and provided it to the bodies.
I just have some questions about the letter. I was here in 2022 when we dealt with SAPA. There were two competing SAPAs, one which 23 sheriffs were on a letter opposed to, probably for similar reasons that they're opposed to this bill. The other one they weren't opposed to because it had a civil penalty. I assume that's the reason. My question is this: last year we didn't see that letter when this bill came forth, and then we didn't see that letter this year until just last week. So I assume that the sheriffs, if this is their issue, they haven't changed their mind, but we've certainly had a lot of change in the legislature. So why the delay in getting the letter out?
Thank you, Mr. Chairman. Last year, we attempted to amend the bills as we have this year, and that was not successful last year. And depending on the direction of the membership of our body and whether to make that a public discussion or just a committee discussion, it was different last year than it is this year. There was no committee discussion over the summer, no interim topics. I'm not aware of any chief or sheriff in the state of Wyoming that was contacted regarding this legislation. We expected it based on the statements that were said at the end of the last session that it might come out. But in my experience, it's very uncommon to see bills again in following years that are exactly the same as they are before. There's always some sort of difference or change or update or whatever it may be. And as soon as the bill that we have before us and the one that looks just like it on the other side of the house appeared on the website, conversations started occurring. And it takes responses of over several days to get consensus from up to 83 different agencies, 23 different sheriffs, and various other partners in our world that are working shift work and providing services back home. Can't be in Cheyenne for 4 weeks and are covering 100,000 square miles almost of work back home. So it's a much slower process, Mr. Chairman, for our group than it is oftentimes for the legislature.
Okay. All right. Representative Sherwood.
Thank you, Mr. Chairman. Just want to clarify that we received this letter on February 11th. So it was 15 days ago.
Any further questions or comments? Seeing none, thank you for being here, Mr. Thompson. Please introduce yourself and let us know your thoughts on Senate File 101.
Okay. Good afternoon, Mr. Chair and committee members. My name is Carl Germain, and I serve as the Lieutenant Colonel for the Wyoming Highway Patrol. I'm here today to testify to the effects Senate File 101 will have on statewide law enforcement operations. While I strongly support protecting constitutional rights, the bill's broad prohibitions on cooperation with federal authorities will severely undermine law enforcement's ability to combat serious crimes in Wyoming. Federal data shows 45 to 50 Wyoming residents are prosecuted annually for federal gun crimes, often involving violent offenders, straw purchasers, or cartel-linked trafficking. These cases frequently stem from local state referrals and task force work. Without cooperation, many won't be prosecuted at the level due to jurisdictional limits. Examples include combined drug gun cases, common in narcotic prosecutions where gun charges stick, where drug thresholds aren't met federally, violent crimes in Indian country, sexual offenses with ancillary weapons violations, transnational crimes investigated by the FBI, fugitive task force cases with U.S. Marshals, ICE cases on illegal immigrants possessing firearms, oftentimes tied to cartel gun trafficking from Wyoming purchases. And a quick note on the ICE cases, the majority of those cases are sent to deportations, but there are several cases or potential upticks where firearms are being found and these individuals are linked to gang activity or cartel activity. I personally have an example I can speak to if needed in that regard. About 47% of federal cases, case referrals come from task force officers and state and local law enforcement. Yet this doesn't capture additional work by state local officers providing testimony or support. For state agencies like the Wyoming Highway Patrol and the Division of Criminal Investigation, this would drastically reduce partnerships with federal agencies, leaving sex trafficking, narcotics, and violent crime investigations unprosecuted or underprosecuted. The bill prohibits using state funds, personnel for any federal firearm enforcement cooperation with severe penalties, including agency fines and misdemeanor charges for officers, creating a chilling effect. Wyoming Highway Patrol supports the WASCOP proposed amendments, which add necessary exceptions and clarifications to preserve critical joint operations without undermining Second Amendment rights. Thank you for your time, and I'm happy to answer any questions.
Any questions for Lieutenant Colonel Germain? I'd like to ask you, your thoughts on the federal prosecutor using some risk management decision-making that I asked earlier. So if you would please opine on that question.
Mr. Chair, oftentimes cases that are brought to a federal prosecutor are pretty severe in nature. And I'll use an example that I had personally, since I can speak to it. And this was some years ago. It was prior to the 287G task force. Resulted from a traffic stop for a state statute violation. Ended up searching the vehicle with consent from the driver and found submachine gun style assault weapons with thousands of rounds of ammunition and thousands of dollars of U.S. currency in a hidden compartment within the vehicle. Through the investigation, determined that this person was here in the country illegally, but was tied to cartel activity. The only state charge that I had was a traffic violation. And without the help from federal law enforcement and the federal prosecutor, that investigation obviously would have stalled. I would have had no recourse to charge this person because the gun crimes weren't illegal at that time in Wyoming. This person wasn't a felon. I don't know what the prosecutor is going to do in a case like that. This is a severe criminal that's tied to cartel activity, that's doing heinous crimes potentially with these firearms. So from a point of risk management, if that case is referred to the prosecutor, that's a lot of risk that you're asking the Wyoming Highway Patrol to take on. And it's probably going to lead to us taking a step back from participating in federal task force and then taking other avenues with prosecution or figuring out how else to charge that individual. We're not in a financial position to where we can handle significant fines, as well as I would hesitate to put a trooper in that position to where he or she could risk their career based upon the way that this statute is written. I do feel that if this body were to adopt the WASCOP amendments, it would be a lot more workable for the Highway Patrol to go out and continue conducting law enforcement the way that we do today.
Thank you for that answer, Lieutenant Colonel Germain. In your example, though, that person wouldn't have been a citizen, so this law wouldn't have applied in that regard. But also, there would have been a second potential charge for the federal prosecutor to go after, and that would have been the citizenship, breaking our laws that way. Isn't that true?
Mr. Chair, at the time of this traffic stop, I mean, it was 15 years ago. I can't speak to what the immigration laws were, but what the charge was this person was an illegal immigrant that was in possession of a firearm, and that's the charge that the federal prosecutor was able to get to go through the court system. That person is still afforded due process, or at that time was afforded due process. We went through a suppression hearing. I had to provide video, written testimony, as well as get up and I take the stand. I understand the citizenship aspect of it, but I question the way that this bill, with this bill being the way it is written today, if that trooper, or if I would have been allowed to go do that.
Lieutenant Colonel Germain, do you believe that non-citizens have Second Amendment rights in the United States?
Mr. Chairman, no, I don't.
Okay. Thank you. All right, any further questions for Lieutenant Colonel? All right, thank you very much for being here. We appreciate your testimony. Please introduce yourself to the committee and to the public and give us your thoughts on Senate File 101, please.
Thank you, Mr. Chairman. My name is Mark Jones. I'm a national director with Gun Owners of America. I do live in Johnson County, Wyoming. This is at least the 5th legislative session that I've worked on different versions of this bill. Some died in committees, various outcomes, the various versions of these bills. And I want to point out from the start that both I and my organization are very pro-law enforcement. I have held multiple meetings with some of the gentlemen that just left the room, I believe, Mr. Thompson and others at the Buffalo Law Enforcement Center. We have repeatedly reached out to law enforcement to try to find a way to do this legislation to where they can enforce the law and catch bad guys, but the rights of law-abiding people are protected. There's been a lot of comments made here about what this bill does and doesn't do, and our attorneys have looked at it. We don't see that it stops enforcement of ICE operations. We don't see that it stops enforcement of drug operations. We don't see the sky is falling, as we've heard today, and I know that's heartfelt. This is a law that's designed to protect law-abiding people. And we've heard a lot about how Wyoming law enforcement are all 100% pro-Second Amendment, and none of them would ever infringe upon the rights of anyone. And I think that's true for the vast majority of our law enforcement officials, but as Representative Pendergraph has already alluded, we have a case in Wyoming where local law enforcement cooperated with ATF against a law-abiding citizen whose only crime was he got a restoration of rights certificate. His only crime, this is important. This is very important. Randy King's only crime was he had a restoration of rights certificate issued by the state of Wyoming. He got a letter and he got a certificate. The governor's name was on the letter. Department of Corrections issued these documents to Randy and told him he had his rights back. 20-year-old drug conviction. So Randy did what anybody would do. He went and brought his guns back in his house. Now, the federal government had the right to raid him. Well, I wouldn't say the right. The way our laws are enforced in the United States these days, the federal government could raid him and that can't be stopped. But local law enforcement went with the federal government to raid him, despite the fact that he held a restoration of rights certificate issued by the state of Wyoming. Now, Randy has sued. This is an ongoing case in Wyoming. Someone made the comment earlier, the feds can't force us to do anything. So I guess they went along voluntarily on this raid. I think this is important to remember. You know, I live in Johnson County and I worry sometimes whether there will be retribution against me because my organization has been involved legally in some of these processes. Now, for the record, I'm as pro law enforcement as anybody. But this law is designed to protect law-abiding citizens. And there are cases where it's been needed. Randy has a second mortgage on his house to bring up the civil lawsuit that he's brought under different statutes. Okay? There are other statutes, and it's a much harder legal climb under current Wyoming statutes for Randy to seek compensation. He was injured. He spent tens of thousands of dollars defending himself against the ATF, and now he's mortgaged a second mortgage on his home to try to seek some recompense from the state of Wyoming. So let's don't pretend like this doesn't happen. And let's don't pretend like we've not tried to work really hard with law enforcement. And I stand ready, whether this bill passes or fails, after this session's over, if the governor vetoes it or it goes into law, to continue to work with law enforcement. I want to make that clear. My goal and the goal of my organization is to give law enforcement every tool they need to put bad guys in jail while also protecting law-abiding citizens from unconstitutional federal overreach. I could go on, but in the interest of time, I will cease my comments. And you know, I testified for this bill when it passed through the House committee, when the House version passed through the House committee. This is essentially the same bill with some minor wording changes, but it doesn't change the meaning. And we stand in support of the bill.
Questions for Mr. Jones? Representative Haroldson.
Thank you, Mr. Chairman. Mr. Jones, looking at this, I mean, and I hear your testimony and I definitely understand your concern as we look at what happened up in Sheridan County. Can you talk a little bit about this conversation though that we're having? I mean, because there is fear on both sides, and I understand this fear. So talk about a little bit of, like, we hear this unconstitutional. Why are we taking unconstitutional out? That type of stuff. Can you speak a little bit to that conversation and maybe what the attorneys that work just on firearm rights, what they're saying about this, and kind of, can we get that picture a little bit?
Mr. Jones.
Mr. Chairman, Representative Harrelson, there's an old joke that if you put 11 attorneys or 10 attorneys in a room, you'll get 11 different opinions. I think it's actually more like 20 different opinions. You know, but our attorneys have looked at this, and basically what they come away with is what I said in the beginning. They don't view this as stopping any ICE operations, any drug operations. They view this as stopping operations aimed at firearms. Like the ATF raid in Sheridan County, that would have been clearly stopped had everybody understood. It should have been stopped by the restoration of rights certificate. You know, I would have thought that If I was a law enforcement officer, the first thing I would do was look at the gentleman's criminal history, and I would have said, oh, he's got a restoration of rights certificate that comes from the governing authority that's over the local counties. Maybe we ought to pause. But yeah, our attorneys don't believe this does anything other than stop cooperation with firearms related activities.
Further questions? Mr. Jones, the case that you alluded to also had some other charges as well, did it not?
There were not charges that were a purpose for the raid. There was allegedly 4 ounces of some narcotic, I don't even know what it was, found in his home, in his safe. But number one, that was not the purpose for the raid. ATF sent a letter to every federal firearms licensee in the state of Wyoming 3 months after the raid and pretty much told everybody why they raided Randy Kane. In their letter, they said, and I'm paraphrasing, I can get you a copy of that, the state of Wyoming is issuing restoration of rights certificates for nonviolent felons for federal convictions, and they do not have the authority to do that. So the purpose of the raid was a firearms-related raid. Mr. Kane, if you've ever met the man, you know, he's had a clean record for 25 years. He doesn't believe the drugs were even his. I don't know. I wasn't there. But allegedly there was a small amount of drugs found in that raid, but that was not the purpose for the raid.
Mr. Jones, you also were here in 2022, based on your testimony. I know that to be true. So, and you brought a SAPA bill through a legislator, and that SAPA bill is in law today. It had a civil penalty rather than a criminal penalty.
I'm
sorry.
It had a criminal rather than civil.
Criminal rather than civil, that's right. So tell me how you worked with the sheriffs at that time and how you came about that, and whether you think that's been successful so far. Obviously, the one case that you shared.
Yeah, so that's a great question, Chairman Bear. This is the 5th session that I've been involved in this. There's been more iterations of this than I can count, to be honest with you. Some have died in early death, some have passed, some have been vetoed by the governor. The criminal penalty that passed in 2022, there was a lot of confusion at the time, and I think even until recent weeks, a lot of confusion among legislators on what's criminal and what's civil. But you are correct, Chairman, that current Wyoming statute 9-14-203 makes it a crime under Wyoming law to do the kinds of things we're talking about today. Part of the frustration from the public is that there have probably been some cases that should have been looked at by the prosecutor that wasn't, perhaps the Sheridan County case. So, and our organization has been consistent across the country, you know, and we're in all 50 states. I live in Wyoming, my children are in Wyoming, but we're in all 50 states. You know, states need both a criminal and a civil process. A citizen who's aggrieved, like Randy Kane, deserves an opportunity to go to civil court. Now, I've heard a lot of talk about frivolous lawsuits, and I don't think you're going to see that. Mr. Kane has had to get a second mortgage on his house to hire an attorney. It's not easy to sue the government. But I think citizens do deserve an opportunity. And again, I believe the vast majority of law enforcement officials are looking out for the constitutional rights of citizens. But there are cases where things go off the rails, and a citizen deserves the right to go to civil court. And that's essentially what this bill does. And it should also be made clear, the civil process is against the department. We have always been consistent in that we do not believe that individual officers should be sued. That would be a chilling effect and hurt recruitment. But this civil process is against the department, and it's designed to be a deterrent to a department's budget. Sheriffs should be making wise decisions about what they do and do not participate in when it comes to federal firearms-related activity.
Mr. Jones, as we talk about the difference between civil and criminal, last year there was a bill passed that brought civil penalties for a gun crime or a gun confiscation issue. Can you discuss that?
Yes, Mr. Chairman, you're referring to the red flag prohibitions. I believe those passed in 2024. And they essentially provide a civil path for a citizen to sue specifically over a red flag gun confiscation order. This bill essentially would broaden that beyond what the 2024 legislation did.
So obviously that's specific to red flag laws, and we don't have that situation right now. So there's probably been no cases where there's been lawsuit brought for that. But when that bill was going through the legislative process in 2024, did you see the pushback from the law enforcement that we're seeing today?
Mr. Chairman, no. Oddly enough, there was not a lot of opposition to the civil lawsuits being available specifically for red flag gun confiscation orders. Not near as much opposition as we're seeing now. Obviously, this bill protects things other than red flag gun confiscation orders. And that is obviously a bone of contention with opponents of this legislation.
And Mr. Jones, the $50,000 fine that is in the bill right now for a violation, how would that compare to the attorney's fees that you mentioned earlier that would be necessary to bring suit against the government?
Chairman Bear, without giving up too much of the gentleman's personal information, I can say that's probably about the minimum to get a good attorney to take a case. And most of them want to do these kind of cases. They don't want to do them as my brain is shot from, they don't want to do the percentage of the winnings. They want the money up front. Okay. And it's probably at least that much up front to take the case. And that's because the cases are really hard to win. So they want to be sure they get paid. They don't expect to win.
Okay. Representative Pendergraft.
Thank you, Mr. Chairman. I just want clarification for what I think I heard. We have two different laws in statute now, one the red flag one and one current SAFA. One already has a civil, one already has a criminal. Did I catch that accurately? And I'll have a follow-up.
Mr. Chairman,
Mr. Jones.
Representative Pendergraft, yes. So currently if a citizen is subject to a red flag gun confiscation order, they can sue in civil court under Wyoming law. Currently, Wyoming statute 9-14-203 makes it a crime for a public official to enforce any unconstitutional federal gun control, basically. You could argue that should apply to lots of things beyond red flags. What this law does is expand the opportunity for citizens to sue departments civilly for violations that aren't red flags. There's lots of different ways a citizen's Second Amendment rights could potentially be violated.
Follow up. Go ahead.
Thank you for that. So it seems to me that we've already passed a criminal in one spot, a civil in another. Can't we lift one and apply it to the other and vice versa so that both have a civil and a criminal and they've already been approved and worked throughout? Why is this? I guess my question comes down to why are we getting resistance now when we didn't before on the other bill?
Mr. Jones.
Mr. Chairman, Representative Pendergraft, I really can't answer why the resistance is so heavy now. I just know that the red flag civil processes were not as controversial and the criminal processes were not as controversial. This one seems to be getting a lot more opposition. And again, I'll just point out from my perspective is, and there's lots of firearms groups involved at various stages. We have worked honestly and diligently for 5 years, and if the door has always been wide open. I've had more meetings than I can count with sheriffs and with Mr. Thompson and with members of this legislature who came to those meetings. And again, regardless of what happens, I want law enforcement to know that we're happy to work with them in the future. You know, my ultimate goal is to see the citizens protected while they can do their jobs. But I think this is a good bill. I think we've worked hard to get to where we are.
Okay, further questions? Seeing none, thank you very much for being here, Mr. Jones.
Thank you, Mr. Chairman and
Right.
committee.
We're going to go to the 3 people online. I don't know if we'll get through them, but will you be able to be here tomorrow morning okay, great. So we're going to try to get through these 3, but if we don't, those people who are online, we'd like to hear from you. So we'll make sure that you're first up in the morning if we don't get you taken care of this afternoon. The committee will need to be down on the floor at 2 p.m. And we only have a short window to get some work done down on the floor. So we'll keep working through this, but we're going to leave at about 5 minutes till the end of the hour. Welcome, Mr. Dorr. Please introduce yourself to the committee and the public and give us your thoughts on Senate File 101.
Mr. Chair, members of the committee, Aaron Dorr, representing tens of thousands of members of Wyoming gun owners across the state. They do actually live in Wyoming. Just want to get that clarified from the beginning. Mr. Chairman, I'm not going to go through much what the bill does. You've heard this on loop now for a long time this session and for previous years. I'm going to jump right to the things we've been hearing about the bill for the last a couple of days and the last couple of hours here in the committee. We heard about the question unconstitutional being removed from page number 3, line number 19. That's being done, Mr. Chairman, because the current iteration of SEPA is so vague as to not be any real comfort to gun owners. If the word unconstitutional is in there, it's up to the department to make their own determination what is and is not constitutional. That's wide open for both confusion and abuse. What we've done here by removing that word is made it very clear, just provide no assistance to the federal government when it comes to enforcing federal gun laws. So far from being confusing, we have removed that confusion with this word being removed from that section of the bill. We've heard a lot about the idea of, the U.S. attorneys taking over cases or can't take cases. It is established fact that the U.S. attorney can take over a case anytime he or she wishes. So if a Wyoming police officer makes an arrest on a case and there's issues as to who can charge for what has higher penalties than the other, nothing can stop the U.S. Attorney's Office from taking a case anytime he wants to file that case in federal court. And if that happens, there's no liability to local law enforcement because they did not work with the U.S. Attorney to make that situation happen. We've heard a lot about, Mr. Chairman, about how we're going to stop the assistance coming from the federal government. I draw your attention to page 8, lines 6 through 7. And page 4, line 11 through 12, that makes it very clear all assistance can be received from Wyoming, from the federal government, to aid in the enforcement of the laws of Wyoming. That means everything from money to personnel, databases to helicopters, all possible help can be received by Wyoming to enforce Wyoming law. We heard this committee heard testimony last time about the horrific situation involving the Sheridan Police Sergeant Krinke, who was murdered. We were told in committee that this bill would allow that murderer to possibly walk free. That's absolutely not the case. All federal assistance can be received by Wyoming to aid in the enforcement of Wyoming law. We've heard about cops being civilly sued. I think we're all on the same page on that now. Page 9, lines 1 through 2 makes it clear only the agency or subdivision has any civil liability. We've heard about when Wyoming cops can seize firearms. It's very clear as well, Mr. Chairman. Page 8, lines 18 through 20. Nothing stops Wyoming law enforcement from seizing firearms and ammunition as part of an investigation into a violation of Wyoming law. Heard a lot of examples given over the last hour or so, these various cases. These things are illegal at the state level, and they can then be prosecuted. If they're not illegal at the state level, these things should be addressed by a separate bill, but not by trying to kill a bill to defend gun owners in the state of Wyoming. We heard about the task force implications, Mr. Chairman. This does not preclude task force cooperation on anything other than going for firearms. Page 4, line 1 through 2. So all other task forces, FBI, DEA, ICE, tribal, those can all continue with no complications. If a department's, we heard the phrase, the insurance agencies. If a department's insurance adjuster tells the department they have to remove themselves from these situations, that is not because of the impact of Senate File 101. and that cannot be laid to Senate File 101's feet. They definitely are allowed to continue. We heard about in the 287G program, Mr. Chairman, how Wyoming cops who are hired or who are attached to these task forces through 287G would not be allowed to be rehired in Wyoming. That's absolutely false. That program is an ICE partnership that has nothing to do with going after firearms and ammunition. And as such, an officer who is a part of that task force could certainly still work as a Wyoming law enforcement officer. Again, Wyoming cops can still help the feds and federal prosecutors, even if firearms are involved in cases involving felony drug crimes and felony persons crimes. Page 7, line 22 through page 8, line 4. And that means that any conceivable, sexual assaults, homicides, armed robberies, narcotics distribution, all of these cases and many more, the feds can still receive help from Wyoming to arrest those suspects, to detain them for the federal government. That's all perfectly allowed in the bill on that section. We heard the supremacy clause invoked. We are not with SF 101 prohibiting what the federal government may or may not do in Wyoming. That would probably be a supremacy clause violation. This bill does not limit the feds. It simply says that Wyoming cops cannot aid the federal government in enforcing federal gun control laws. We heard examples about illegals and guns and when they could and could not be charged. Again, on page 9, line 12 through 16, it makes it very clear that felons, foreign nationals, and non-residents do not qualify for coverage under SEPA. This only protects law-abiding citizens in the state of Wyoming. We heard in committee testimony recently, maybe not today, Mr. Chair, but recently, about how those who are arrested but have not yet been prosecuted or have been convicted yet would then be immune. That's a sensational statement, because a person in jail for a homicide is simply not going to be released in almost any situation in Wyoming pending trial. Mr. Chairman, a couple more small things we heard about. Page 8 was referenced in prior testimony today about solely and what that could or could not mean as far as a liability to a department. If you look at page 8 in that section that talks about solely, the precursor to this, Mr. Chairman, is page 7. And page 7, line 13, section F, is a list of all the ways that you do not violate SEPA. So that section is being cited in testimony as what the bill would do. It's the reverse. The bill does not, in fact, do those things. That was mistakenly presented, I believe. We heard about the Prinz case, Mr. Chairman. The Prinz case did, in fact, tell the feds that they could not force localities to help enforce federal gun control laws. That's true. But nothing in the Prinz case precludes the federal government from borrowing local law enforcement, from hiring local law enforcement as part of a joint interagency ATF task force. The whole purpose behind this is to make sure that cannot happen in the state of Wyoming. We heard one last question, Mr. Chairman. We heard why is there so much opposition to this now? I can answer that question, Mr. Chairman. The answer, I think, is very simple. The bill that passed in 2022 had some gaps. And when you have the word unconstitutional in there, that's a problem, because it's wide open for abuse. That's why we didn't see opposition. When you have criminal penalties and no civil penalties, I think we've all now realized that the prosecutors will simply not be bringing cases like this against local law enforcement. So there was no real functional penalty provision inherent in what happened in 2022. What we're doing here is to button up that law. That, I believe, is why we have significant opposition this time. And happy to answer any questions, Mr. Chairman, and or to speak to the amendment that I believe may be offered on this bill.
Any questions for Mr. Dorr? Representative Sherwood.
Thank you. Good morning, afternoon. I don't know what day it is. I'm just curious, where are you joining us from today?
Get this question a lot, Mr. Chairman. Happy to answer it. I work in a bunch of states. I live in Missouri. I have directed WIGO for 10 years and passed a whole bunch of gun laws in Cheyenne. I'm there all the time.
Thank you. And can you remind me how many Wyoming?
Through the chairman, please.
Thank you, Mr. Chairman. How many Wyoming members that you represent?
Mr.
Yes,
Dorr.
Mr. Chairman, tens of thousands.
Follow up?
If you don't, that's quite vague. If you don't mind getting me an exact number, that would be great.
Mr. Dorr.
Mr. Chairman, that question is unanswerable right now on the fly in a live committee hearing. So I think it's pretty obvious from all of our previous activities. We have a lot of members that have passed a lot of bills in Cheyenne, and we're very proud of that.
Okay, Mr. Dorr, I have a question, and it does have to do with the word solely, but I didn't find what you were talking about on page 8. I'm more talking about page 3, line 16. And you've heard the testimony today, I assume?
I have, sir.
Okay. And so here we have the word solely, and I heard you say that you felt that that's a non-issue because it's easily definable. The concern that we've heard today has to do with, frivolous lawsuits where they see an opportunity. Is there a way that this could be tightened up? I see that we've removed the words administer or cooperate, so it looks like there's already been some tightening on this use of the word solely. Is there any other way to make it so it's not so easy to bring lawsuit?
Thank you, Mr. Chairman. I think that perhaps I know what your question is, but I think perhaps you may be reading that backwards. From the way we have drafted this, this is the most amount of protection to preclude against frivolous lawsuits because there's only a violation if the firearms are seized by an agency that is solely seeking to enforce federal firearms laws. And so that actually gives the maximum amount of flexibility to law enforcement and the minimum ability, I believe, to gun owners to file these cases because there's all kinds of latitude then for firearms to still be grabbed and arrest to be made if the purpose was not solely to enforce these federal firearms laws.
Okay. All right. Any further questions for Mr. Dorr? Representative Harrelson.
Thank you, Mr. Chairman. Mr. Dorr, thanks for joining us today. I would assume that you were a part of the hearing yesterday where the amendment was placed on House Bill 130.
Yes, sir, I was, Mr. Chairman.
Can you give us a high level what this does to the bill, the pros, the cons? Basically, in the end, what are the cliff notes? I've read it in, so I think I have an idea. But I just think especially for the people listening, what does this do, and kind of what are the concerns brought forward in your mind with it? And let's just have a dialogue on that.
Mr. Dorr.
Mr. Chairman, thank you for the question. I do not have a copy of the most recent iteration of the proposed amendment, but as you and I know, we've met multiple times with law enforcement in the recent past in the building and discussed their proposed amendments. My understanding is they're going to reinsert the word unconstitutional on page number 3. And as I said a minute ago in my testimony, if that word is in there, absent any qualifiers, that alone negates the impact of this bill because it's wide open to interpretation. And you don't have to take my word for it, sir. That's why law enforcement was not opposed to the iteration that became law in 2022. By having the word unconstitutional in there, it is a real problem. And effectively, it kills the bill. If there are any efforts to remove the civil penalties, that also would kill the bill. And again, you don't have to take my word for it. That's why there was no opposition to what passed in 2022, because there were no civil penalties in there. So we have multiple different ways here where this bill would be negated. And we'd certainly be urging a no vote on any amendment that would come from that direction.
Follow up. All right, Mr. Dorr, thank you for being here. We appreciate your testimony. All right, let's move on to, I think we've got somebody from Uinta. We have Ms. Callis.
I have just added Loretta Callis to the meeting.
You know what? Yeah, we're down to 1 minute here. So if you could reach Ms. Callis and Sheriff Hodge and let them know we'd really like to have them here tomorrow morning.
Okay.
And we're going to recess this meeting and come back at 8 a.m. tomorrow morning. So hope you all can join us then. We'd like to hear from everyone. Okay. Thank you.